And we are live. Good evening, everybody. This is Gerard, as usual, from Johannesburg. As you join us, if you can let us know, please, that you can see us. You should see the video of Renata and you should hear me. Just waiting for some response. Then we can move on. Wonderful, wonderful. Good thing you can see Renata, not me, all that well. Much prettier than me. Any case, so Renata is a very, very well qualified person in many things like estate planning, taxes, trusts. You can ask her lots of questions. She knows a lot of things. She's one of these people that like to read laws and boring stuff like that. So I'm sure she's got lots of information that I'm too lazy to study. So Renata, welcome.
Thanks.
You're going to talk about opportunities or ways to avoid what is that horrible word? Business rescue.
Well, yeah, basically ways of dealing with your debts in your business is what we will be discussing today. Yeah.
So yes, welcome, and please save your questions for at the end. So Renata can do a presentation about 40-45 minutes, and then you can hit her with all your questions. Enjoy, Renata. I'll be in the background if you need anything.
Thanks, Harald. Thank you. And welcome, everyone. Thanks, guys, for your time and spending the evening with us, or hopefully not the evening, but an hour of your evening with me. So what I would like to recommend, maybe in the chat, if you do have questions, as you have them, just pop a Q and then your question. And what I will do is at the end, I will go through the questions, because what I find is when I do present, I get so excited to answer questions, and then I completely go off the track. So I try to leave the questions for at the end, but you are welcome in the chat block to post your questions. I will actually close the chat block in the interim so that I don't get distracted, and then I will open that at the end. I have done a little slideshow a presentation just to keep us on track of what we will be discussing. And yeah, but please do reach out, ask questions, and you are also welcome to reach out to me after this webinar. I will also probably be in touch with the registrants just to thank you for your time tomorrow or during the week. So what I will do now is just share my screen. Yes, that's the right one. And there we go. Okay, so as you can see, we are tonight talking about dealing with debt in your business. And yes, I have done a mountain of research here, and I've worked very closely with an attorney friend of mine that I've known for the last 20 years, who specializes specifically in debt and liquidations. And we've joined forces because we know that so many businesses are taking strain at the moment. And where possible, we want to make sure that we can at least arm you guys with the right knowledge and the right information, and give you some tools and options to rather continue trading if that is the best option and the bones are good. In other words, the business is still viable, that we rather continue trading than just to step out of the business. And if business rescue is not the answer for you, to not enter into that. Often when people think debt, they think there's only business rescue or liquidation. And as we go through tonight's presentation, you'll see that actually it's not the only options available. So let's get into this. The things that we will be talking about tonight, let's just move faces out of the way, is I'm going to talk a little bit about statistics, the difference between security and surety. I'll talk about the different classes of creditors. I'll talk about the different options available with our debt. And then I'll talk about the tax consequences of when we are looking at paying different debts. So when we try and change our debt arrangements. And why am I the one here? So as Gerard said, yes, I do like reading and research, but I also have been in the trust and tax game for the last 20 years. I sold my shares in an accounting firm 2 years ago, and I decided to go full-time into dealing with small business owners and training and really optimizing businesses. And a big part of that is the tax and the dealing with debt. And also, of course, dealing with the estates whilst they're alive. And of course, when parties pass away, then dealing with the deceased estates. So basically anything where I have to do a long drawn out sum makes me extremely happy. And anything where tax is involved, I get extremely happy. Nothing excites me more than a new tax book. So that is why I'm here and I'm talking about this topic, because needless to say, there's always a tax implication somewhere, and the same applies when you deal with your debt. So let's get into this then. Let's have a look first when we enter into our credit arrangements. Really, I think the big thing is, do we really read the fine print? And I think that is often not the case. Very few of us do. I mean, they give you these long-winded papers with very small print, and very few people are going to read it. But let's look at some statistics before, and I'll be referring to my papers as I go. So as we all know, the banks did offer some payment holidays in the early parts of the hard lockdown, so late March. And for those 3 months that the banks actually offered these payment holidays, the result of that was that 20.7 billion in debt was really added to the debt. And that was only the impact on an estimated 1.6 million South Africans. So can you imagine to escalate the debt by 20.7 billion rand? That to me was already quite an eye-opener. The Credit Bureau TransUnion did a survey in August. And the survey in August that they ran, already by that time, 21% of those surveyed and that took part in this survey had reported losing their jobs as a result of the pandemic. So that's 21% of people that had lost their jobs as a direct result of COVID. And also at the same time, already 9 out of 10 people, so almost 9 out of 10 people were already saying that they were concerned about how they were going to pay their debt. Now, this was only run for individuals. But if this is the impact on individuals, you can see that that would have a knock-on effect on business. Then at the end of September, we had further reports where it was well publicized that by that time already we had lost 2.2 million jobs. Now, when you take a step back, understand that these are also, how can I say, official jobs. These are not your informal sector guys that may have someone or spin-off jobs. So for instance, where you have outsource agreements, where I would have maybe my business, and although I don't employ my IT guy and I don't employ a guy that looks after all my printers and machinery, and I don't full-time employ a marketing person, but all these people are outsourced. So although they're not on my payroll and they're not part of my business, when my business goes in, all these people all of a sudden also lose those contracts. So it does have a knock-on effect. So what I'm saying is, when we're saying we've lost 2.2 million jobs, those are also only the official employed in a particular. Oh, sorry, a picture just came off my wall. Sorry about that. So that is my concern with the 2.2 million. It's really just the publicized figures. So that was really the figures come in September. By end October, the unemployment rate which included job seeker, well, discouraged job seekers, I should say. So those are the people, how they define that, I'm still trying to figure out. But a discouraged job seeker, which is someone that is still able to go out and find a job, but is not actively doing so. So the unemployment rate by early October had gone up to 42%. Now, all these statistics, the only reason why I'm bringing this into this presentation is for you to understand that if this is happening outside of our businesses, it will have an impact on our businesses, on the spending power within our businesses, and what we are then as a result able to do inside our businesses, because we need to sell to our clientele. But if the clientele does not have the money to buy, who are we selling to? And this is probably why you are here tonight. So yes, that would then be the statistics. I don't need to go further into any of it. I'm sure that every time you read news, when you hear news, you would certainly get more and more of these statistics. So moving on to the difference then between security and surety. So what happens often when we enter into credit arrangements? Like I've mentioned, that fine print, that would often say, okay, hold on, what are you giving me as security? So what is security? Security is really just an alternative way for the credit to be paid. So for instance, if Noble Prosperity, my company, is entering into an agreement to buy something on credit, whoever is extending that credit wants to know, but hold on a minute, if Noble cannot cover this debt, if Noble cannot honor its agreement, who will step in and carry that? And then the Renata, for argument's sake, would come in and now become the security. What does Renata have that basically they could attach if need be? So security is basically that someone else, something else that would cover that debt. Surety is just one form of security. There are also other forms. So we would have things like mortgage bonds, those are on fixed properties, or notarial bonds, those are on movable assets. We would have cessions of debtors, that's when people take over your debtors book, pledges, guarantees issued by financial institutions. So you see, there are different ways of dealing with security. But surety is one way of dealing with security. When we then look at the suretyship, that is really where one party is responsible for another party. So again, where Renata may be responsible for Noble's debt. Now, in suretyships, often it's basically an accessory contract. And that accessory contract, the underlying thing with that is that it has to be valid. The debt has to be valid. And really, what makes it valid? It could not have prescribed. So it can't be older than the 3 years and followed up. So that prescription rule is very clear on that. And there are other, how can I say, protection that could be in there, but very often when you sign these things, lines are put through that or it's excluded, which means that as the end user, as the person that has the debt, you may not be covered and you may not have the protection that a surety may have offered you if they had the clauses in that normally gets removed. So the formalities of sureties, this is the interesting thing. Formalities of suretyship is embodied in the General Law Amendment Act 50. And here's what it says. It has to be in writing and the surety has to sign it. Full stop. End of story. So you see now that the wording of the contract is thus the most important part of the surety agreement or the security, whatever it is we've signed, because the wording of that agreement will basically determine the rules of engagement. And that's why it's so important that we understand what we sign. The problem is often when we trying to secure the debt, we are in a position where we need the debt. So it means that maybe our back is against the wall, or maybe we haven't read the fine print, or maybe we're not in a position to negotiate. Whatever that may be, just be aware and understand what it entails. What we have also found quite interesting is when people come and see us and we start looking at the paperwork, often what seems to be or appears to be an ironclad surety or security is actually not. So you need to really look at the wording to understand how ironclad this is. So that's all I want to say on that topic. There is different implications, if I can call it that, with surety. So remember I said earlier that there are various options with debt. So the three that I will be discussing is liquidation, business rescue, and debt compromise. Now with those three, they would also have a different impact when it comes to a surety. When I've signed this document, what would be the impact on that surety? So with a liquidation, needless to say, the surety will be enforced. The suretyship would be enforced. With a business rescue, it's quite different. With a business rescue, basically what happens is for as long as that business remains in business rescue, it cannot be enforced. In other words, no one can come and attach. There are conditions where you can escape liability, and that would be the business rescue practitioner or the plan must expressly provide for the discharge of creditors, or the suretyship agreement must be silent on the enforceability against the surety in the event of a business rescue. So if you have a document that is very explicit around business rescues, then one would have to look at what that wording says. Now, in a Section 155 debt compromise, basically what happens there is the suretyship is not exempt. The compromise does not exempt the suretyship. So what happens is a compromise means I'm now going to change the terms of my debt. I would pay less on different terms. And so if I have debt of $1 million, I compromise to 800,000, but my surety is at $1 million. What could in effect happen is even if I've paid that 800,000, the surety could still be enforced. And that's why it's so important that when you do deal with someone to help you with a debt compromise, that the compromise agreement is written properly and that this specific matter is dealt with. When we do those debt compromise agreements, we make very, very sure that we handle the sureties and that we would actually waive those sureties. That if we've compromised debt, that you can't after the fact go and compromise, go and enforce the surety to now get more money. So again, the key takeaway here is the wording of that contract to really understand the consequences of that agreement. Okay, now if we look at, where's my mouse? Here we go. Classes of creditors. And you'll see why classes of creditors become important. But basically a class of a creditor indicates who will get money first. And depending on what type of way you're going to deal with your debt, that would determine basically who's going to get paid. So that is when these classes of creditors become very, very important. So a secured creditor, the three types would be the secured, the preferent, and the concurrent. The secured creditor, that is the guy that's got some form of security. So you have signed an agreement and you've said, if I cannot pay you, well, then I will give you this, or then Joseph will pay, whatever that agreement looks like. That is a secured creditor. When you look at a preferent creditor, well, that is someone that legislation determines gets paid before a concurrent creditor. So the secured guy would stand first in line because he's got something securing his debt. For instance, I've got a bond And that bond is secured, a mortgage bond is secured by the property I bought. So those two go hand in hand, and they would now stand in front of a preferent creditor. A preferent creditor, the law says, hold on, this guy gets paid before anyone other than a secured or preferent creditor. And that preferent creditor would be SARS or employees or your maintenance claims when it comes to personal matters. Then your maintenance orders would also fall in under preferent. And for those, you don't need security. You don't need to prove security to get money there. But like I say, they would stand behind the security guys, the secured debt, I should say. So they would stand behind the secured debt, but in front of concurrent. Concurrent, those are your normal trade debt. These are the guys that you've got 30 days, 60 days, whatever it is, you've got no form of security, and they're not SARS, they're not employees, and it's not a maintenance order. So they are your everyday debt guys. Those are the concurrent guys. And this is important because when you enter into any one of the various types of how I will deal with my debt, they will also deal with how these guys would get paid. So in the case of a liquidation, you would work out what the cents to the rand is, and the secured guys would get theirs first, then the preferent guys would get theirs, and if anything was left over, the concurrent guys would get theirs. If you went into a business rescue situation, again, it would be dealt with in order of class of creditor. But here, what's very important to remember is that SARS will now stand behind the employees. So in a business rescue, the employees are even more important than SARS. So SARS, I must tell you, is not particularly fond of business rescues. I'm not saying that it is not entertained. I'm just saying if they have other options, they would prefer those. And then when we look at a debt compromise, well, there we can decide with which class of creditor will we compromise the debt. Because with a secured guy, he's going to go, why must I negotiate with you? I've got security for my debt. You don't pay me, I'm going to take this asset. And the asset is enough to cover the debt. So you may not want to negotiate with that guy. But it may be that those are the guys that are willing to negotiate because maybe the asset does not meet the debt obligation. But what's nice is that you can actually go and negotiate with a class of creditor and not necessarily with all classes of creditors. So it does give you a bit of wiggle room. So that is our different classes of creditors. I hope I've given you a better understanding of what these silly words mean. Now, what are my options available when we are dealing with debt? So really, what can we do about the debt in our business? And now I will talk a little bit more about these three options. So as I've mentioned, we've got business rescue, we've got liquidations, and we've got debt compromises. I just want to keep an eye on time because I'm very mindful I do not want to keep you longer than the allotted time. So with business rescue, my view, now what I must also say to you is remember that this webinar is work I do and my opinion and what I feel comfortable with. People may agree with me and people may disagree with me. So my personal view on business rescue is, yes, it may certainly work for some businesses. However, I feel that it's expensive. It's quite a tedious process, and sometimes there can be a lot of unnecessary costs wasted. So again, I'm not saying it's not an option. I'm just saying in some businesses, it may be the only option and we would need to do it, but understand what you're getting into. So what is the process with a business rescue? Well, a business rescue practitioner would be appointed, and that person, basically, the management of the business now vests in that person. So it means that that person now becomes responsible for the running of this business. Now, already, we now have a bone of contention because the directors, the people that were running the business before, all of a sudden now have to report to this person. They have to take lead from this person. Now, that does not mean that the business rescue practitioner necessarily comes in and runs the business. The person may not be qualified to run that particular business, but it is for that person to decide whether they're bringing in someone else to come and run the business, which often they will do, or whether they will issue instructions on how this business is to be run. So there is already something there we need to deal with. The business rescue practitioner, once appointed, like I said, will take over the management of the company. They will then draft a business rescue practitioner or a business rescue plan, sorry. And then if the creditors accept the business rescue plan, they then have the task of trading this business out of trouble and basically adhering to the business rescue plan. So the outcome is that you could trade and you could possibly trade out of trouble, but if you don't, you would land up in liquidation anyway. So me and my figures, as we know, I love myself a little stat. So my statistics on business rescue. And this is my interpretation of the data that is contained in the Business Rescue Process Status Report. So this is a report that's published, and these stats are as at 14 August 2020. Okay, so this is the Business Rescue Process Status Report. It's available. You can go on the internet and you can get it. And as at 14 August. Now, how this report works is they actually report on all business rescue cases from date of inception. Date of inception for our country, 2011. So from 2011, 3,738 cases have been lodged. So open, started, 3,738. So for ease of reference, 3,740. Okay, cases lodged. Since 2011. Now, remember that. Since 2011, so we're now talking, let's give or take 9 years. Of those cases, 698 ended in liquidation. So of my 3,738, 698 of them end in liquidation. So we couldn't save the business, sadly. But of those 3,738 cases, 468 cases were terminated as, and how they term it when it's been successful, not financially distressed anymore. So their report doesn't say it was successful, it just says not financially distressed anymore. So financially distressed is an official term that basically means that the company can in the next 6 months not honor its debt obligations, or is likely to liquidate within the next 6 months. So not a rosy picture. So when they say no longer in that position, for them that's a win. So of all 3,700 cases lodged, 468 cases were successful. So I then go and do my little sums and I go, okay, hold on a minute. That's 12.5%. Okay. So what about those in the middle? Give or take 2,500 cases. So since inception lodged, since 2011 to date, there's about 2,500 cases somewhere, still in between. So they're in between liquidated and successful, which means they're somewhere in the process. So can you understand that? Can you imagine you go into a business rescue process and it starts dragging on and dragging on? And a lot of these figures, when I was looking at them, they were continuing for on average 3 years. So again, I'm not saying a business rescue is not an option. I'm not saying it's a bad option. I'm saying that for some businesses, it may very well be the option. But understand what you are getting into. So for me, the two main things about a business rescue that one has to take into account is the fact that the management of that business is vested in the business practitioner, the business rescue practitioner. And another thing that we need to take into account, once a company has gone into liquidation, they cannot be pulled out and put into business rescue. So you need to decide when you are in a position where you know that your business is in financial distress Or you are looking at it and you're going, I'm not officially in financial distress. Remember that financial distress means officially 6 months from now, between now and 6 months, I cannot honor my debt obligations, or in the next 6 months, I may liquidate. I may not yet be there, but things are tight. So once you go into liquidation, you cannot enter business rescue. It is too late to enter business rescue. But alas, not all is lost. So let's look at liquidation then. Now, often people feel that with the liquidation, now all is lost. So with the liquidation, sometimes it is the only answer for a particular business. This would be if we can see you cannot trade the business out of trouble. The bones are no longer good. No matter what you're going to throw at it, you're just not going to be able to save this business. Then sometimes liquidation may be your only option. But you know, with liquidation, more than just the business owner loses. Your employees lose, your suppliers lose, the landlords lose. Now, that may be the least of our worries, but all these people down the line lose. So it's not just for the business owner that this is a sad day. The process would be that a liquidator would be appointed. So if the business is placed in liquidation, a liquidator would be appointed. That liquidator would then basically come, sell all the assets, and then pay the creditors what is referred to as a dividend. A dividend is basically the portion of the money that will come to you as a result of your percentage debt. So again, it would work on what class of creditor you are, as I mentioned earlier. But here's the thing about a liquidation. Even if you have entered into liquidation and you are in a position to actually pay your creditors, you can come out of liquidation and you can pay your creditors and you can continue trading. You know, sometimes what happens is guys are forced into liquidation because they've had people that haven't paid them for the longest of time, and it's a big deal. And then all of a sudden something happens and the payment comes through. Now they can honor their debt. At that point, we can then take them out of liquidation and pay the debt. Or the other alternative is they've gone into liquidation already, and now the guy comes and he says, listen, I've come into some money. I can now enter into a debt compromise. So I can't pay my creditors 100% in full, but we can enter into a debt compromise. In other words, pay whatever that portion is that we had agreed on before. And then we can again pull that business out of liquidation and enter into a debt compromise position and continue trading. So the liquidation doesn't have to be the absolute death of the business. Now, when we get to a compromise, and this is where I spend a lot of my time, my energy, and really in the hopes that we would be able to keep more businesses going. With a debt compromise, it's really a very underutilized alternative to business rescues and liquidations. And what I found so interesting is I did a talk to an auditor and her audience, a webinar to an auditor and her audience. And I've done the same to an attorney and her audience. And both of them said to me, but hold on a minute. We know about business rescues, and we know about liquidations, but we don't know about debt compromises. Because you see, debt compromises are almost like the stepchild. No one talks about it. Probably maybe because the people that do it don't make quite as much money. I can't tell you why it is. It's really underutilized. But the funny thing is that it is part of the Companies Act. That's why it is Section 155 of the Companies Act, where we can actually use it. Excuse me. So what is a debt compromise? It's really an arrangement where we enter into an arrangement to pay less on different terms. But here's the thing. It can also be made an order of court. So now it's set in stone. So think about this. If you now enter into a debt compromise with someone, you've now made an agreement to say, I will pay you X amount on these terms, and it's made a court order. So now people are guaranteed, I'm going to get the money and it's going to be sorted. So it's not this if, when, maybe, possibly. No, this is what it looks like. These are the agreements. This is the court order. So what is interesting here is that, like I said, it gets made an order of court. And the process again is that, like with the business rescue, the attorney would come in, they would draft a debt compromise agreement, let's call it. So they draft this agreement. And this agreement would then set out the difference between if we liquidate versus if we debt compromise. And so the agreement would be drafted. Then there's a meeting with the creditors. And if the creditors then agree, one would enter into this agreement. The agreement would be signed and it would be made an order of court. And then really it's business as usual. But what are the benefits of a debt compromise? Why would we take this over the other guys? So first and foremost, for me, in a debt compromise, the directors remain in charge of that business. So they remain the management of that business. Now, people may say, well, why do you want to keep them in management? They already got the company in trouble. But if we look at it, if we look at the unforeseen circumstances where we have found ourselves in 2020, if you got yourself into trouble in your business, it may not have been through any doing of your own, other than we had a hard lockdown. Then we had like semi-lockdown. A lot of industries, even after the hard lockdown, were still under lockdown. And a lot of industries are still very restricted in their trading. If you go and look at the travel and tourism, if you look at venues like conferencing and things like that, it's become virtually impossible for these people. Expos, people that run big expos, you cannot run expos. I spoke to a client of mine today that actually does auctions. As an auctioneer, he can only allow a certain amount of people into the venue. The problem is he's already got staff, a huge number of staff in that building, and he has to have security to actually control the crowd, because now people come from all over, and I'm talking as far as Durban to his Gauteng auctions, and they can't get in. So now they get very rowdy, and they actually have to have security to stop people from trying to get into the building. So you can imagine that that would have an impact. So again, at least now with a debt compromise, my management is retained within the directors. It also has less formalities and timelines. So if I can explain it almost like a deceased estate, because maybe some of you will be more familiar with that. With a business rescue, what happens is you have a specific task, and then you have a specific timeline. So now you have to advertise, and it has to be so many days. Then you have a certain step, and it's so many days. And then it's a certain step, and it's so many days. It's very formal, very specific. With a debt compromise, although there are certain steps to be taken similar to a business rescue, it's not as formal and it's not as time conscious. It's not, okay, now wait for 2 weeks, now wait for 21 days. No, it's do the agreement, enter into an arrangement, and let's run with it. Also, another benefit here, the company does not have to be in financial distress. Now, remember, financial distress is that 6 month rule. Can I honor my debt in the next 6 months, or will I liquidate? Now, sometimes you can't guarantee that you're there, but you know, if something doesn't give, if something doesn't change, it's only another 3 months and you will definitely be there. So the beauty about the fact that you don't have to be in financial distress is that you can act sooner rather than later. So you don't have to first go and get yourself into a position where now there is really no getting out of it. Also, you can choose which class of creditor you will compromise with. I said that earlier. You've got a lot fewer reporting criteria. So that doesn't mean that you can hide things, but you don't have these very stringent requirements on reporting, which of course also reduces the cost. Because remember, with every rule that you bring in and with every requirement that's brought in, there's more costs. And of course, that is the next point. The costs are less. Also, the fees of this compromise will include also the appointment of a receiver. Now, what is a receiver? That is the person that is appointed, let's call it on the back end, that ensures that the court order or the agreement that has now been entered into is honored. So the person that's almost like a buffer between the debtor and the creditor that will make sure that if we've agreed to honor the debt in this particular way, that is going to happen. And as part of that, where we in any event get involved with the debt compromises, part of that is where we will try and guide those businesses to optimize the businesses, to see how we can trade them out of trouble quicker. What systems can we bring, set in place? What is it that we can do to improve the trading? Then also the compromise, as I mentioned earlier, even if you've been placed in liquidation, you can come out of liquidation and enter into a debt compromise. There's no moratorium on legal proceedings. Now, what that means, simply put, is for as long as there's no court order that says, by the way, guys, this is now how you're going to pay, it means that other creditors can also crawl out of the woodwork and they can now also come to the party. So what generally happens is when we enter into these agreements, the guys are quite quick to come to the party and they're quite quick to reach an agreement because they know the longer they drag their heels, the more the opportunity for people to change the rules of the game or for more creditors to come to the party. So very often these debt compromise agreements are reached very quickly. It's a relatively quick process compared to the other processes. And then, of course, SARS. So as I mentioned earlier, SARS does not exactly jump for joy when you go to them with either a business rescue or a liquidation, because it's not going to be great for them. But with a debt compromise, SARS knows that they are probably going to be better off and they have a better guarantee of getting their money because it's a court order. Here is, however, the conditions. You may not have been in a debt compromise with SARS in the last 3 years. Your taxes must be up to date. In other words, your submissions must have been up to date. You can't have not submitted for 14 years and now say, I want to compromise my debt. And the third condition is you must be able to prove to SARS that in the event of a debt compromise, they would be better off than in the case of a liquidation. Now, that's always going to be the case. Otherwise, you wouldn't enter into the debt compromise. So couldn't have been in a debt compromise in the last 3 years with SARS. Your taxes are up to date, your submissions, and they must be in a better position than if you liquidate. And then generally, we find that it's a much more favorable process. So how do we start the process then? What is the process for a debt compromise? Well, basically, the most important thing is that you deal with someone that understands what they're doing, that knows how a debt compromise works. Because like I said earlier, it's the words that will trip you up. In that agreement, when that compromise agreement is drafted and you don't take care of all the nuts and bolts, what you don't want after the fact, when you think you've paid everyone, that more things crawl out of the woodwork. So very important that you actually deal with someone that not only understands the tax, but the law as well. So it's a legal and a tax thing that must work together. It can't just be an attorney or just a tax specialist. These two people or the two parties really need to work together on something to make sure that that compromise is dealt with properly. And what are the steps? As I mentioned earlier, the process is that proposal is drafted, and it's really a 3-step proposal or a 3-part proposal. It's got a background, basically, how did I get here? Then the proposal, how do we propose to do this? And then the assumptions and the conditions. So assuming this, and these are the conditions that needs to be met. The meeting with the creditors, the agreement of the compromise is then made in order of court. The receiver is appointed. Remember, that's the person on the back end that makes sure that everything runs smoothly. And then it's business as usual. So I've often also been asked, does this affect my credit record? Now I'm talking about a debt compromise specifically. And what is interesting to note is that the offer to compromise, they refer to it as an offer to compromise. The offer to compromise is lodged at SIP-C only. So it's not lodged at the credit bureau. So it's not lodged as against your credit. It's only at sub C as an agreement that we've entered into. So that's actually quite interesting to note. It's not really that mark against your name. However, and I always say this, it's a matter of ethics. If you are in debt compromise and you are paying your way out of that debt, it's only the ethical thing when you're entering into debt to make sure that when people say, are you in business rescue? Have you been liquidated? That you, at least if it is going to impact where you are at this stage, I'm not talking if the debt has been paid up and business is fine. It's not something that you carry with you for years afterwards. But if you are currently still in that position, that you have to be honest about it. Okay, I think now the next one is, oh, my favorite thing in the world, tax. Okay, so what is the story with tax? So you see, the thing with tax is this. It can be quite technical. My favorite thing in the world. So here is the thing. When you look at the tax consequences, when we are dealing with what we can do about our debt, there are various sections, let's call it, that come into play. And these are only the income tax sections. There are also, of course, on the capital gains side, there's also that one must look at. But these are only the income tax ones. So section 8.4a, and I don't expect you to even care about these sections, but I want you to just, one day when someone says something, you're going to go, I remember that Pop said something. So section 8 is about recoupment, and I'm going to explain that by way of this sum. And then there's section 19 and 24J. So 24J always deals with interest things, and 19 would be to do with your stock, I think. But really, to just give you a quick example, check on the time, we're still good to go. So let's just use this, and why I wanted to show you guys this. Because so often people will go, okay, don't worry. You know what? I've got these assets. So I've got a couple of delivery vans, for argument's sake. If I just sell some of my delivery vans and I settle my debt, I'll be good to go. And I'll go, that may be a very good plan. But what's going to be the impact from a tax point of view? I may have stopped the hemorrhaging as far as the debt is concerned, but what is going to be the impact as far as my tax is concerned? Let's have a look. So here the example is, we have a vehicle that we bought for 400,000. And then we claim our wear and tear. Remember, that's our depreciation of 20% per annum, because that's what we get on a car. And then after 2 years, we now sell this vehicle. And we get 343 for it. But now remember, I bought it for 400. I sell it for 343. But that's not where it ends. I also had depreciation on it. So let's have a look, see. I get 343, but SARS goes, wait a minute, you had a benefit. The 400,000 that you had, what was your wear and tear on it? Oh yeah, it was that 20% for year 1 and year 2. What's that? Gives me 160,000. Okay, so what's my portion that I did not have a benefit on? SARS says, where didn't you get tax benefit? It was that 240,000. So SARS goes, okay, cool, no problem. So you don't have to worry about that section. So I get for the car that I sell 343,000. SARS says, but don't worry about the 240,000 because you never claimed wear and tear on it. I say, thank you very much, SARS, very kind of you. They go, but hold on a minute. Remember that 103,000, this difference here now. That was the benefit that you've had with this as a result of this wear and tear. That 103,000, you must now go add it back to your gross income. Now, stop before you have a heart attack. This does not mean I'm going to pay 103,000 in tax. No, no, no. All it means is it's like on all my other income that I've had for the year, I add to that 103,000. So the maximum I would pay would be that 28% on top of that. So 28% of 103. But remember, I would have had other income and expenses for the year. So it's my income and my expenses. So what this 103 basically means, it's almost like other income, like sales from something or interest I've received or whatever. It's another form of income. It's like a deemed income. So I hope this makes some sort of sense. But really all I wanted to say to you is before you go off and go, oh, let me sell some stuff. Let me go smose my stuff to pay my debt. Understand, we can't just smose your stuff. We need to look, and that's why I keep saying, yes, there's the legal aspect, but there's also the tax. We need to understand, because sometimes we do something and we get ourselves into bigger trouble. There's another one where the capital gains can really become a problem, because if I've negotiated my debt and I then sell an asset, even though I bought it for 400,000 and I sell it for 300,000, but I've negotiated my debt somewhere else. SARS goes, but hold on a minute. Your base cost was no longer 400, it dropped down to 0. And now you've got a capital gains of 300. Now that's a lot more technical. I'm not going to go into that, because for that I'd need a whole hour to explain. But all I'm saying is that, and very often, please understand, that your accountant that deals with your normal company accounting may not necessarily be the guy to deal with this kind of tax. When I say with this kind of tax, what is the result if I negotiate my debt? Remember, your company accountant, I'm not saying he won't know. All I'm saying is your company accountant's job is to make sure that your VAT's up to date, that your taxes are up to date, that you don't get into trouble. They don't specialize necessarily in debt compromises and the tax consequences of that. So also just make sure that if they don't know, and that's where I work a lot with the company accountants and the lawyers on these kind of things, because people specialize in certain fields. Like I know diddly squat about import and export taxes. A lot of people would know a lot about certain topics. So I think, is that it? Oh, that's it. Oh no, I've come to the end of my discussion. So in closing, all I want to say then, and then I can stop sharing my screen and go to the questions, is that if you do find yourself in a position where you think that you need to look at the debt in your business, and maybe even just personal debt, because we can also assist with personal debt. I prefer the company debt, but personal debt as well. You're not alone. There are many people out there that can help you. I'm not saying that I'm the only person that you need to reach out to. There are many, many people at the moment. I hear ads on the radio and on the radio all the time of people that can help you. There are many people that can help you. But certainly you are welcome to reach out to us. I would love to assist where I can, and make sure that you deal with people that specialize in this. People that specialize in dealing with debt. What I mean with that is tax specialists that deal with debt, as well as attorneys that deal with debt. Even attorneys would specialize in certain fields. So do deal with people that specialize. And, we've even created our little catchphrase, don't hesitate, negotiate, which means don't hesitate. If you know that the debt thing is really keeping you up at night, let's negotiate your debt. Let's go see what we can do. Let's try and make this problem go away where we can. So let me stop sharing the screen. Let's hope no more pictures fall off the wall and give me a heart attack. Let's go to the chat block, and I see there are no questions, but at least I still have people attending. I've got lots and lots of people attending. So either, Gerard, maybe you want to open your mic. Either I have gotten everyone to sleep with all this debt talk, or they've run for the hills. Guys, please feel free to pop us some questions there in the chat block, or some comments. If you've got some feedback, I'd love to know what you thought of this discussion. I do appreciate that not everyone loves tax and figures and debt as much as I do, but I do hope that maybe this has given you a little bit of ammo, and that you just know how to deal with it a bit better now. Gerard?
Yeah, definitely. I think I've been in business.
Wait, hold on. I know my speaker goes quiet when no one speaks to me for a while. Are you there, Gerard?
I'm here.
There we go. Sorry, the speaker, after half an hour, if no one speaks to me, it goes dead. There we go.
Oh,
okay, cool. There we go.
So yes, I've been in business where one feels totally lost, and you don't know where to start. So it's good to know there's people that like to read laws and know what to do and what not to do, like you.
Thank you, man. Thanks. And thanks, Lavon. I see you've posted a message there that it was informative and you've learned a lot. Thank you, man. I think what I need to do, let me just quickly go here. I'm going to pull up my blog, but I'll do a search for debt quickly. I posted a number of articles. Last month was my month for debt. And so what I did is I posted a whole bunch of debt articles specifically to cover this topic. If I post this link, Harrod, will they be able to see it?
Yeah, you can put it in the chat.
Oh, to all, can I do it to all attendees? Okay, I see what I can
All
do here.
panelists and attendees.
Paste, enter. Okay, now everyone will be able to. So that would be the link to my blog. That would be all the debt articles. Obviously, there's a bunch of other articles. This month we're talking about trusts. But yeah, there's that. And then I've also got a podcast show, and there I've also spoken quite a bit about debt and what we can do with our debt in our businesses. So yeah, it is 5 to 8. And if I don't get any questions in, then I think that I've kept it quite on time. Great.
Well done. Yeah. Oh, so someone says, thank you. Now I know there are more options than just liquidation.
Yes.
There's a question that someone asked, and I know Mary is in Australia. Is this for South Africa only?
So Mary, yes, I specialize in South African tax and South African law things and South Africa trust. I am sure that Australia would have their versions of these things, but unfortunately, I cannot speak for Australia. I haven't done any research for the Australian market. So yes, when I've addressed this, I've addressed it as for the South African market.
But surely, you know, especially Commonwealth countries would have very similar basis, you know, on tax
Certainly.
and stuff like that.
Yeah, certainly. Remember that the Section 155 debt compromise that I was referring to, that is based on our Companies Act. So if the Companies Act is the same, there may be similarities. It depends on what the Liquidation Act stipulates. Again, so this would tie in with your Companies Act in your country as well as with your Tax Act. But yes, that's why I say they would have similar, but whether it would be the exact same as in South Africa, that I can't say.
But yeah, and I'm sure there will be practitioners that can assist in whichever country you are. Yes, an interesting question, which I think would be difficult to answer. Costs of rehabilitation.
Yeah, that I cannot answer you because I think it is dependent on quite a number of factors and it's quite an individual thing. I've seen various figures. So that would be, again, I know the attorney would have to have a meeting. It depends on what creditors were impacted and the time frame that's gone by. I know also, was it a voluntary liquidation versus a forced liquidation? So those things would all impact on it. But it's certainly, if that is something that you want to inquire about, please reach out to me and I can put you in touch with my partner and we can certainly answer that question for you. Thanks, Mary. So yeah, okay, that's all I see. I just want to make sure I haven't missed anything. No, looks like I haven't missed anything. Yeah, and apologies, guys, for that ruckus earlier when my very expensive painting came down my wall.
Oh, I hope it's not damaged too badly.
Wow, yeah, I'm going to have to see because it's, yeah, funny that. So I don't know what happened there. Okay, yeah, I think that's it. It doesn't look like we've got anything else coming in. But yeah, I really enjoyed the presentation and I'm glad that you guys have learned something. Yeah, feel free to reach out.
Definitely worth listening to you and your wisdom.
Thanks. You know what I'll do? Sorry, I'll just put my contact. If someone wants to reach out, I can just put the link there as well. Copy, just to make it easy. Paste, and there we go. check at that.
Yeah, so
I'm getting the hang of all these buttons that one needs to press. Eh? Nothing like a little lockdown to sort us with our computers.
yeah, for sure.
Okay.
So I'm sure they, okay.
Shame, Mary. So Mary says there was a time in a younger year she would have loved what you is it you would have loved what you do with such a passion. Yeah, I must admit, I get very excited if I can sit in a dark corner with a very thick textbook. That makes me happy. You want to see me flustered and unpleasant and throw me in a room full of people with live, warm-bodied people. I'm much better like this. So, yeah. Horses for horses, I suppose.
It's not entirely true. I've worked with Renata for a few years, and she can
That's
be
true, man.
sometimes. I must.
Yeah. Look, I don't mind. Once I get to know them, once I get to know the people, I'm good. So. Okay, Gertjie. Well, it's been fabulous. Thank you for being on the back end and making things happen there and pressing all the right buttons and for the opportunity. It was great. I really enjoyed the chat. And and thanks for the interaction, guys. And thanks for spending your evening with us.
Yeah. So and we'll get some communication through to whoever attended, and then you can maybe get connected with Renata if you have any questions or need assistance or try to make SARS happy or something like that. By the way, SARS is our local receiver of revenue.
Yes. Yeah. So yeah, just a disclaimer, guys. My aim is not to make sure that we pay as much taxes as possible. My aim is to make sure that we stay on the straight and narrow and stay out of trouble. So when I say I love anything tax related, it's because I love the rules that goes around it and to see how we can get around it. Certainly, we want to be, as I had someone that worked with me, my ex-partner in business used to always say, yes, we want to be honest, but we don't want to be fanatical when it comes to paying tax. So yeah, we'll be honest, but we won't be fanatical.
Yeah.
So there we go, guys. Thank you for your time. It has been great. I've had a great time. And I bet you a wonderful evening. I hope you have a great one and hope to chat to you all soon again. Thanks, Harold. Have a good one.
Good night, everybody.
Bye-bye.